好，接下来进入到我们第3个单元，印度买方的坏账减损及理赔实务的分享。相信大家都有听说过，印度的法规是多如牛毛。那万一您遇到印度买方拖欠账款的时候，真的是毫无头绪，要怎么处理？因此我们这一次直接邀请到印度当地专精商业法规及仲裁的大律师，为大家介绍印度与债务处理有关的5大法规，希望可以帮大家指点迷津。那在此我也特别提醒一下大家，记得打开一下您的英文字幕，应该可以有效帮助您理解等一下演讲的内容哦。Okay, so please join me to welcome the partner lawyer from Mumbai office of Classes Law, Mr. Mustafa Motiwala. Mustafa, over to you.
Thank you, Kevin, for this kind introduction. And I'll be presenting on the process and the points regarding debt recovery mechanisms in India. So there are a few statutes which govern debt recovery in India, and I'm going to cover all of them briefly in this presentation. First, and the very popular one, is the Insolvency and Bankruptcy Code 2016. Second is the Commercial Courts Act 2015. Then we have the Arbitration and Conciliation Act 1996, which has got several amendments, which I'll come to. The Negotiable Instruments Act 1881, but still effective. And last but not the least, the Mediation Act, which is fairly new in 2023. So Insolvency and Bankruptcy Code is a comprehensive code unto itself, which has a time-bound process for resolution of insolvency if the company goes in for liquidation or if the company goes in for a resolution process. It is for private limited companies, for LLPs, and also for guarantors. It will soon be applicable for individuals, but yet the law is not notified for individuals, but that's going to happen soon. So this slide will give you a brief idea of how successful the Insolvency Code is in India. This talks about a creditor's claim which is admitted and realized over the years. So the gray bar talks about financial creditors, and the bluish bar talks about operational creditor. Here, since you are in trade and business and services, your clients may be, so therefore operational creditor is what will be more useful to you to understand. So the amounts are mentioned in USD millions, and you can see how many millions of dollars have ended up in resolution of the debt, and how much has been achieved through liquidation. Now, what is important to note is that under the Insolvency Code, there's been special tribunals set up to hear cases, and it does not go to regular courts in India. So because of which the resolution is faster, and matters would reach hearing faster. As you can see from the map here, there are a lot of benches set up, and each bench will have several courts. So starting from north is Chandigarh, New Delhi, Jaipur, Ahmedabad, Mumbai, that going down south to Bangalore, Chennai, Kochi, towards the east side, Kolkata. So these are the several benches here. There are 2 appellate benches, which are set up in New Delhi and in Chennai. And from the appellate bench, the provision of statutory appeal, which goes to Supreme Court, which is New Delhi. So there are certain prerequisites for initiating a CIRP, or what we call a corporate insolvency resolution process. Now, this is important for the audience to note, that you can proceed under the Insolvency Code only if the debt is of Indian rupees 10 million, which is roughly around $120,000. So that is the threshold limit. If you are below this threshold limit of $120,000, then you cannot proceed under Insolvency Code. The limitation period for suing under the code is 3 years from the date the debt became due. 3 years is a long time. And what is important in one of the definitions is that there should not be a pre-existing dispute. This would mean that the debt should be undisputed, and it is better if the liability is admitted by the debtor in some form, in writing or an email or other means of communication, and that will help. Now, this is again important, that who can initiate proceedings under the IBC. So one is, of course, voluntary by the corporate debtor, which is not really applicable to you. The other one is by a financial creditor, which strictly speaking may not be applicable, but I'll just take you through that. If there is a financial debt, then the financial creditor can issue insolvency. Typically, a financial debt would mean money is lent by banks and financial institutions. But what is more important here is the operational creditor. That is any creditor who owes money, in view of a commercial transaction or goods sold and supplied or services delivered. So here is the definition, that any person to whom operational debt is owed and includes a person to whom such debt is legally transferred. So even an assignee of a debt can sue as an operational creditor. And as you can see in the second bullet point, in operational debt, the meaning is that a debt which arises out of business transactions for supply of goods and services. So which covers everything in terms of its business. Process of initiating CIRP. Okay, so this process is also very important, and it has to be followed to the hilt. It has to be followed fully. So what happens first? An operational creditor gives a statutory demand notice to the defaulter. Now, this statutory demand notice is compulsory as per the law, and one cannot ignore it. This statutory demand notice can be issued either by the operational creditor themselves or through their appointed lawyer. Generally, what I have seen in India is that the stat demand notice is issued by the lawyer, so that there are no technical defaults in the notice and it is given to the hilt. Everything is followed as per the requirements of the law. What is important, that the demand notice has to be very much in detail. That is shown in the second box here. The details of the entire debt, what was the transaction, how did the debt arise, what was the business dealings, everything has to be mentioned in detail in terms of its narration of facts. And all invoices or agreement or any other communication which is relevant to the debt, or everything has to be, first of all, narrated in detail and also annexed to the demand notice. So what happens next? The demand notice is then served upon the registered office of the operational creditor. And the operational creditor can do two things. One is that the creditor can, the debtor can say that, look, there is already an existing dispute, or there is some claim filed in court, or maybe there's an arbitration pending, and therefore this insolvency is not maintainable. Okay. Or secondly, and simply, he can produce a proof of payment and say, look, Mr. Creditor, I've already paid you and this is wrong, which is fine. That if he's paid, he is paid. Now, if the operational creditor does not receive any response in 10 days from the date of service of the stat notice on the debtor, then the creditor is entitled to file a petition or an application, as we call it, with the relevant bench of the NCLT. What is important here is that when we are talking about the debt has to be a crystallized sum of money and should not be disputed. Meaning thereby that if a particular debt is arising by way of damages, okay, then it is not qualified as a debt under the insolvency code. It has to be a fixed sum of money. Basically, it has to be contractual, either stated in your invoice or stated in your contract. And once the petition is filed, an opportunity will be granted to the defaulter or the debtor to defend his case. Then the NCLT will satisfy itself whether the debt is capable of being admitted. And if the debt is genuine, if the NCLT feels, then it will admit the petition and grant a moratorium period And immediately there will be an appointment of interim resolution professional, which is akin to a provisional liquidator. So this stage in the matter is extremely important, because if your debtor is an operational running company, it would not want an IRP to be appointed of all its asset and its company coming to virtually a standstill. So it would rather pay up the money. So at this stage, I have seen that a lot of matters do get settled in the Indian jurisdiction. Procedure during the CIRP is important, but I will take you through this quickly. First of all, as I said at the top of the pyramid, that if the petition is admitted, then there is an appointment of the interim resolution professional. The IRP will then issue public notice inviting claims and proof of verification. So therefore, what happens is that once a public notice is given, all other creditors will stand in line, and make their claims before the IRP. The IRP will verify the claims. If he has any questions, then the questions will be asked to those creditors. And subject to the IRP's satisfaction, the claims will be admitted in the entire process. There'll be a formation of a committee of creditors, which will comprise of lenders, secured creditors, if there are any, and a certain value of unsecured creditors as well. Once the COC is appointed, then instead of the IRP, a resolution professional is appointed, which is akin to a liquidator. So the IRP can continue as the RP as well, or a new RP can be appointed. There are several circumstances which will determine that, which I will not take you through just now. What happens next, broadly speaking, is the RP will then invite bidders to give a resolution plan as to if any company is interested in buying over this company which is under the CIRP process. Once the resolution plan is approved, the NCLT would pass an order to that effect, and the creditor's debts will be considered to be satisfied as stated in the resolution plan. And if there is no resolution plan, or if there are no bidders for the company, then the RP will proceed for liquidation of the assets of the corporate debtor. So the typical liquidation process will follow, again as per the insolvency code. And the disbursement of all the debts which has been submitted with the RP and earlier the IRP will then be in accordance with the provisions of the insolvency code. What is important here is certain timelines. Is that the entire CIRP process has to be completed within 330 days, subject to any extension that may be granted by the NCLT for several reasons. Yes, please. There's a recent reported judgment which I thought will be useful for this presentation, so I've made a note of it here. Is about credit insurance. So typically what happened in this matter, just to put it very shortly, is that here the debtor said that, look, the claim has been paid already by the credit insurance to the operational creditor. So now he has no right to make a claim against the debtor. And this went through the NCLT and to the appellate tribunal and finally landed in the Supreme Court. And both the appellate tribunal and the Supreme Court has held that, look, there is no free lunch in that sense. Even if the credit insurance company has satisfied the claim of the creditor that is under the insurance policy, but that does not allow the debtor to go scot-free, and he is still responsible for making payment to the operational creditor. So this is very significant in today's day and age, because this was a very common defense raised by many of the debtors, and now that has been put to rest.
好的，正如刚刚 Tommy 总监所提到的 ，language barrier 是一个非常重要的 issue， 所以我们在 Mustafa 的 presentation 当中啊，有准备了3个中文的小节，跟大家分享一下，让大家可以更清楚的了解Mustafa 的一个简报内容。那刚刚 Mustafa 有简报到这个 Insolvency and Bankruptcy Code， 那他提到一个重点叫做 CIRP， 也就是企业的破产程序。那这个程序呢，可以由2种债权人来发起，一种叫做 Operational Creditor， 另外一种叫 Financial Creditor。那先讲 Operational Creditor 呢，它就是指的持有 Operational Debt 的债权人。 那这个所谓 operational debt 就是日常的国际贸易啊、商业交易所产生出来的债务啊。那根据这个 Section B 啊、IBC 等等，其中有一个重点就是要发出 demand notice， 而且要在启动 ICRP 之前10天内发出。所以这个 demand notice 是这个 operational creditor 要启动 CIRP 的一个重点。那另外一个部分是 financial creditor。那因为我们这次报名的客户有蛮多的，也是来自银行界的客户，所以我们也帮各位先问到一个问题，就是说，针对台湾也蛮常见的所谓的 receivable factoring，银行所买断的这一个receivable 是应该视为 operational creditor， 或者是视为 financial debt， 这两个。那根据我们之前问过这个律师，其实这是没有，目前印度法院还没有一个标准的答案。有一些法院判这个应该是 operational debt， 另外一种是判是 financial debt。所以对我们来讲，或许还是照这一个最保守的方式来发出 demand notice 是最合适的。那底下有一些门槛啊，或者是限制。那第一个当然最重要的、最直接的金额的部分，12万美金。那大家如果有做一些比较小额的国际贸易，说金额可能低于这个的话，那该怎么办呢？那基本上就是可能通过刚刚等稍后那个 Mustafa 会介绍的 Commercial Act 的部分来解决。那其他的一些相关的限制条件，就让大家来自行参考。那右下角的部分呢，就是如果说经过这个 CIRP 的这个过程，没有办法得到的一个被批准的重整计划的话，那这个债务人就必须得进入到清算的程序了。这个大概是我们帮这个 IBC 所做的一个中文的一个小结。So go back to you, Mustafa.
Thank you, Kevin. The next legislation here is the Commercial Courts Act, which came into force in 2015, and it is really helping in resolving disputes faster and therefore debt recovery as well. So what are the key components under the Commercial Courts Act? How does a dispute qualify to be commercial? Well, there is a long list of definition about commercial disputes under the law, but I have chosen a portion of it which perhaps I thought would be applicable to this audience. So as you can see in the first box, commercial disputes includes insurance, reinsurance, commercial transactions, and contracts, carriage of goods, mercantile, etc. But apart from this, it's a very wide definition. So any kind of commercial transaction will qualify to be a dispute under the Commercial Courts Act. A commercial suit can be filed if the claim amount, that is the threshold limit, is more than Indian rupees 300,000, which is approximately $3,600. So as you see, the threshold limit is very low, and therefore almost any and every commercial dispute will qualify to be filed under the Commercial Courts Act. Why is this Commercial Courts Act important and efficient? Because there are specialized commercial division has been set up by various high courts across the country, and even the district courts, which is the lower courts lower than the high courts in India. So there are specific judges appointed to hear only commercial matters, and that the judge's understanding is quite clear and it moves much faster. Also, very importantly, is a special provision under the Commercial Courts Act, which is what we call a pre-litigation mediation. And that has been made mandatory, meaning thereby that before the proceedings are lodged in the court, there is a compulsory mediation between the parties. And if the parties come to terms or arrive at some settlement, then of course there's no need to proceed to trial or to file in the court, and the matter gets settled there. There is just one exception to this rule, that in case if any party wants to obtain urgent reliefs from the court, meaning thereby if they want to get an injunction order or a stay order or appointment of a receiver or some such relief, then the pre-litigation mediation is excused, and one can go directly file a suit and obtain those reliefs under the Commercial Courts Act. There are very strict timelines for completion of pleadings under the Commercial Courts Act, and that is what makes it very interesting and very attractive also. So the written statement, which is the statement of defense by the defendant, has to be filed within a maximum period of 120 days from the date of filing of the suit. There is an inspection of documents and disclosure and discovery by either side, which needs to be completed within a period of 30 days from the date of filing the written statement or the statement of defense. So it's 120 maximum plus 30. Now, instead of 120, if somebody files in 90 days, then the 30 days in the next point will start triggering from the filing of the written statement in 90 days. Parties to proceedings must submit their statements of admission, denial, and all disclosed documents within 15 days of completion of inspection. So 30 days for, as I mentioned earlier, and within that 30 days, in 15 days, all admission and denial has to be done by the parties. Another important point is that the commercial court is required to pronounce its judgment within 90 days of conclusion of argument by the parties. So sometimes it was seen earlier that courts would take a long time to pronounce judgment. Now there's a reasonable timeline of 90 days from the time of conclusion of trial and final arguments by the parties. Appeal provision is there, of course. An appeal against the decision of the commercial court must be filed before the appellate division of the commercial court within 60 days from the date of the impugned judgment or order. So you have 60 days time for the losing party to file an appeal before the appellate division of the commercial court. Another interesting element of the Commercial Courts Act is the summary judgment. Now what is a summary judgment? So basically, at any point, either party can file an application for a summary judgment, meaning thereby that either party can file an application and tell the court that the plaintiff or the defendant has no prospect of succeeding in the matter or defending the claim, depending on which party is filing the application, and that there is no compelling reason why the claim should not be disposed of before even recording evidence, meaning thereby that there is no requirement of a trial or full-fledged arguments or something. The case is such a flimsy nature that it can go in for a summary judgment. So then the court will decide as to whether this is a fit case for summary judgment or not. And if the court decides, then it can pass a judgment and a decree immediately in favor of the plaintiff. Or if the defendant succeeds, then the suit can be dismissed. And if the judge files that his application is not really possible to do a summary judgment on that, then the application will be dismissed and the suit will proceed for trial. But there are instances where a summary judgment can be passed in a given case where the debt is not really disputed. What is very important that I've seen with many of the foreign entities that we handle in India is about enforcement of foreign judgments. Because even if one party obtains a foreign judgment in a foreign land, how fast or how easy it is to enforce the same in India and actually get the money in the bank. So there's a law around it, and the law is quite settled. So initially, what happens is that the law envisages that whatever decrees are passed by a superior court of a reciprocating territory is directly enforceable as a decree in India. So any competent court, any court who having jurisdiction in that foreign land, if that court is passing a judgment, then the judgment becomes enforceable in India. In case of a non-reciprocating territory, a suit will have to be filed, and the judgment passed by the foreign court will be proved as a matter of fact in that suit to be filed in India, and eventually the judgment will be enforced. So foreign judgment is, this is the positive side, that it shall be considered conclusive as to any matter, except where there are 6 exceptions, that it has not been pronounced by a court of competent jurisdiction. So basically it means that the foreign court passing the judgment should be the right court to pass that judgment. Second point, it has not been passed on the merits of the case. So the judgment should be passed on the merit of the case. I'm sure all courts will pass the judgment on the merit of the case. But sometimes if it is not passed on merit, then it cannot be enforceable in India. Third, it appears on the face of the proceedings to be founded on an incorrect view of international law or a refusal or recognition of law in India's case where the law is applicable. So this has got a two-step situation. One is that it is found on some incorrect principle of law of international law, or a principle of law that is applied in a foreign country is not really the principle of law that could be applicable in India, in which case a judgment can be refused to be enforced by the Indian court. Fourth point, the proceeding in which the judgment was obtained are opposed to natural justice. So meaning thereby that, it's an ex parte judgment, and without giving notice to the defendant, the judge takes a view and passes the judgment summarily, and a defendant has no chance to even present himself in that case in the foreign court, then that would be termed to be opposition of natural justice, and it may not be enforced in India. Fifth point, it has been obtained by fraud. So anything that is obtained by fraud, of course, is not correct and it will not be enforceable. Last point, it sustains a claim founded on breach of any of law in force in India. So if the judgment is based on a particular situation or law, which such application is not allowed in India, in that similar position in India, then that judgment will not be enforceable. But the point here is that once if it is found to be enforceable, the court shall enforce it in the same manner as if it's a decree passed by a court in India. So what I read out just now to you are the exceptions. Okay, but if a judge, basically to put it short, if a foreign judgment is passed by a competent court and on merits of the case, then it will be enforceable in India. Another effective legislation is arbitration. And although the Arbitration and Conciliation Act came into force in 1996, it has undergone a few rounds of amendments, which is making it more stronger in favor of arbitration and therefore resolution of a dispute and eventually recovery of debt. So over the years, what are the major amendments that has been brought in? First is establishment of Arbitration Council of India, but it's not yet established, so I'm not going through that point. Importantly, there is a fixed period of completion of arbitration proceedings, so everything is as per time schedule, and you cannot overshoot that time in arbitration. One concern was that arbitration becomes very expensive in India, and arbitrators charge fees which are very, very high. So the government has come out with what we call a fourth schedule of the Act. There's a particular schedule in which the fees of the arbitrators are fixed depending on the quantum of the claim, and those are fairly reasonable. There is more power given to arbitrators in terms of the proceedings, so they can decide what they have to do for giving justice. There is also a provision for fast-track arbitration proceedings, which is a much shorter timeline than a regular arbitration. Confidentiality proceedings have been tightened, so your arbitration and whatever you raise in the arbitration remains confidential. Appointment of arbitrator interim relief. This is one of the key elements under the Arbitration Act, and I will take you through this very, very briefly. First of all is the appointment of an arbitrator. So generally, as you all will know, arbitration is governed by a contract. So if there are two parties have a contract in which there is an arbitration clause, then they're obliged to go in for arbitration. But for appointment of arbitrator, if one party fails to appoint an arbitrator or the other party does not agree to appoint an arbitrator, then the party who actually wants to proceed for the arbitration will have to apply to the High Court of that relevant jurisdiction to appoint an arbitrator. In case of an international commercial arbitration, that is where one of the parties is an Indian party and the other party is a foreign party, such an application for appointment of arbitrator will have to be filed with the Supreme Court of India in case the parties don't come to an agreement for an arbitrator. And the court can then appoint any person which the court deems fit for such arbitration. Interim relief is some very important part of arbitration. So in case if in a particular situation where one of the parties want to obtain urgent relief, as I said earlier, for appointment of a receiver for assets or injunction or stay or something, then they can go in for an application to be filed in the court. And within 90 days from this application, they have to start with the arbitration proceedings. Yes. I'll skip through this judgment, which reinforces what I just told you. Timelines under the Arbitration Act are very, very critical. So within 6 months, the pleadings have to be completed. Oral hearings have to go on a day-to-day basis, unlike the earlier times. Adjournments granted will be very, very narrow. The time limit for passing an award is 12 months from the date of completion of pleadings. For international arbitration also, it's 12 months from the date of the pleadings. The timelines can be extended by the court, but with the permission of the court, of course, the tribunal can extend timelines. And for a fast track arbitration, as I mentioned earlier, the timeline is 6 months only, and within 6 months, the award can be given in a fast track arbitration. Enforcement of domestic awards, which is again very important. All awards passed in India can be enforced as a decree, except if the party was under some incapacity, or the agreement is not valid under Indian law, or there is a violation of principle of natural justice, or the award deals with the disputes beyond scope of arbitration. So it is, if the contract is regarding a particular thing and the award talks about something beyond the contract and the scope, then yes, of course, that award cannot be executed. Any matter which is not capable of settling by arbitration, for example, divorce laws, etc., you cannot settle by arbitration. If it is against public policy of India, or if it's patently illegal in case of international arbitration, then such awards cannot be enforced. Enforcement of foreign awards, again, if there is a reciprocal arrangement between the two countries, then the foreign award will be enforced as a decree of the Indian court, and it will be binding on all purposes on the persons between whom it was made, and it can also be relied on legal proceedings. It's important to file few documents for enforcement of award. One is the original award or a duly certified copy of that in the country in which it was made. Original agreement or duly certified copy. When I say original agreement, means original arbitration agreement between the parties, and any evidence to show that this is a foreign award. So meaning if you just produce a award duly signed or certified, that itself is evidence that this is passed by a foreign in a foreign arbitration. Grounds for refusal of foreign awards. Again, these are grounds very similar to that of enforcement of domestic award. It's almost the same grounds, so I'm not taking you through again these grounds because of want of time.
现在进入到我们第二个中文小节的部分啊，左手边大家可以看到商业法庭的法案，这针对一些比较小额或者是直接跟商业有关的一些相关领域的一些案件所进行的一个商业法案的适用。那它的一个门槛额度金额的门槛只有美金3600块，所以就没有那么的门槛那么高了。那书面陈述必须在120天内就要提出。左下角的部分就是在全印度的地方法院、高等法院都有专业的这个 commercial division，所以它是比较对于这个商业事务比较了解的一些法官来组成的。那特定的情况底下，刚刚穆斯塔法有提到，就是可以申请简易判决，也就是 summary judgment 的部分。那如果这个案件不需要寻求紧急的临时救济的话，interim relief pre-litigation mediation 是强制必要的，必须要先经过这一个调解的一个程序。那我们看到右边的话是针对仲裁那如果双方没有办法合意选派仲裁人的话，受害当事人当然可以向管辖法院来申请仲裁人。那因为如果是台湾的出口商直接到印度那边是算是一个国际仲裁，那管辖法院就是高等法院了。那右边的部分呢，就是在整个仲裁过程前中后都可以提出这个临时救济都可以提出临时救济。那左下角这边就是它有一些相关的期限，速达之后12个月内来必须要有一个仲裁的一个裁决出来。那当然也可以展延6个月。那国际仲裁这边括号有写只能尽量因为它的法案上面可能会比较复杂一点。 那右手边，如果说有仲裁的话，就可以被强制执行啊，除非这个裁决3个月内有被提出任何的异议。Okay, go back to you, Mustafa.
Thank you. There's this Mediation Act in 2023, which is also very effective. However, the parties should have a mediation agreement, that is a contract in writing to go in for mediation. And there is a strict timeline of 120 days for completion of mediation, which can be extended by a further period of 60 days. So a maximum, you are looking at a 180-day timeline. If the parties agree to a settlement, that is a mediated settlement, then they have to enter into an agreement of settlement. And this agreement now under the new law will be binding as if it were a judgment of the court. So which is a very good position because now the legislation provides for enforcement of mediation agreement. Earlier parties used to do mediation and still not honor it. And again, the party who has to receive the money had to go to the court. But now that has come to an end. There are very limited grounds of challenge of a mediation settlement agreement. And these are extreme cases where there's a fraud or there's corruption or there's impersonation. Only then can an appeal be filed. Otherwise, once the mediation agreement is arrived at under this law, it's over and it can be enforced straight away as a decree of the court. There is a proposition for establishment of a mediation council of India to regulate the mediation institutions, but I guess that is yet to happen, which will happen soon. So what are the benefits of mediation? It's very cost effective. It can be actually done in a few sittings. It's a timely resolution of the dispute. It's a voluntary process. Of course, parties have to agree to it. There are different mediation centers and court related mediation centers also. So there's a vast pool of good and efficient mediators to help you do the mediation. Slowly and steadily, there are a lot of increase in mediation, increase in cases of mediation, and parties are resolving disputes before going to the court as well. It's a very informal process and therefore easy to follow the process. The last legislation in today's presentation is a Negotiable Instrument Act way back in 1881, but it is still followed. The scope of the act was here to enhance the credibility of a negotiable instrument, that is a promissory note or bill of exchange. So basically, I would restrict myself not to promissory note or bill of exchange, but only to checks, because in case where the audience is involved, where business happens, is basically checks which is given by the defaulting party and the check bounces when presented to the bank. The applicability of the act has also been extended to RTGS instructions. Okay, which is online transfer. If those also bounces, then that will be considered to be an offense under this particular law. What is the cause of action here? When does the party be eligible to file proceedings against the defaulting party? Is when a check is returned by the bank due to insufficient funds or exceeds the amount arranged to be paid from that account, or maybe the signature is invalid, or whatever the reason the check bounces, this law comes into force. And a validity of a check, you must know, is a period of 6 months from the date mentioned on the check. So there is also a statutory demand notice that has to be given. Now, as you can see in the first point, demand for payment has to be given in writing to the drawer of the check within a period of, sorry, I'm not able to read it. Period of 30 days from the time the check bounces. Then the drawer of the check from the receipt of that notice has 15 days to make payment. And if he doesn't make payment within 15 days, then within the next 1 month or 30 days, the person receiving the creditor is entitled to file a criminal complaint against the defaulter. And the jurisdiction of the court will be where the check has bounced or where the defendant is residing or carrying on business. The penalties are also important to make a note of here. There's an imprisonment of a term which may extend to up to 2 years, or there could be a fine imposed by the judge of twice the amount of the check, or with both the penalties, depending on what goes on a trial. And in case of a company, all directors and other people responsible can be dragged into the matter and can be made and accused in these criminal proceedings. These offenses are compoundable. and the directors who are dragged into the matter may have a defense that they were not in charge of the day-to-day operation of the business, and therefore they should not be punished and they are not liable for this check bouncing. But that will be subject matter to a lot of things that happen at the trial and evidence. Limitation period in the different statutes, it's important to note. Under IBC or commercial suit or arbitration, it's 3 years from the date the right to sue accrues. And under the Negotiable Instrument Act, as I mentioned in the previous slide, 30 days plus 15 days and another 30 days for filing the complaint. So that is the limitation in terms of the Negotiable Instrument Act.
OK， 接下来是我们第3个，也是最后一个这个中文小节的部分。左手边是针对调解法案，那这边有一些相关的一些期限可以给大家参考。那当然，这个如果有这个调解协议出来的话，就是这个案子最终可以执行的一个结论，就好像法院判决一样。好，那在右手边来讲的话，是所谓 Negotiable Instrument Act， 是票据法案。好，那这些相关的一些规定。留在这边给大家做参考。那我这边特别提最后一点哦，就是跳票的发票公司，它的相关高层将面临到2年最高的一个刑期，或者是最高是跳票金额2倍的一个罚金。所以这个跟台湾可能20年前一样就是如果有跳票的话，那个公司的主管负责人是要去坐牢的哦，给大家参考。OK，thanks for Mustafa's informative presentation. Next is our time for our Q&A session. But before that, let me introduce another knowledgeable expert to join us. 我们非常难得直接请出了 Atradius 亚太区理赔总监从幕后走到幕前来跟我们进行现场的一个互动跟交流。We are very honored to have Mr. Dhiraj Chandra to join our Q&A session. Let's welcome Dhiraj.
Afternoon, everyone. Thanks, Kevin.
Let's begin with a couple questions from the audience registration. First one, I think should go to Mustafa. This audience is a country manager of Taiwanese company subsidiary in India, and he feels that India is a very dynamic and also unpredictable market. In terms of market demand, the buyer's purchase forecast, or even the buyer's estimate payment date, etc. It makes it very difficult to manage it. So could you please give him some advice about how to deal with this kind of uncertain business environment?
Yes, thank you, Kevin. Very pertinent point. And my thinking is that for addressing these kind of situations, it is very important that you have a good, strong contract between the parties. And if there is no contract, then at least your terms and conditions of the invoice or the bill that you raise should be very, very clear, including the rate of interest, the date of payment, and a grace period, if at all there is a grace period. Everything has to be clearly mentioned. Once that is done, or once that is on paper, then it is not, the situation is not as bad as it may appear in case of absence of these kind of clauses in the contract.
Okay, thanks for your advice. Indeed, the contract is very important. Next question, I think should go to Dhiraj. In Greater China business practice, a Taiwanese seller can request a China buyer to provide a trade acceptance, 商业承兑汇票, or even the banker's acceptance, 银行承兑汇票. So this audience is wondering, in India and the Asian country, is there any similar kind of security a Taiwanese seller can practically request the buyer to provide?
Thank you, Kevin. I would say in addition to credit insurance, in my view, the suppliers can ensure they have proper contracts, like Mustafa has said. Having a proper contract in place is the most important. This will enable you to ensure that you are able to enforce your contracts against the defaulting buyer. Just to add, I think if in good days, when the relationship is strong, mutual benefit of demand and supply is there, then everything goes smoothly. only when, when the buyers stop paying, only then you are really have to test the contracts. So having proper contracts is super important. In addition to having a contract, I mean, similar to other regions, like you said, in Greater China as well, Indian courts also, Indian trade system also allows for trade with documents against acceptance, documents against sight, cash against documents. You can also have bank guarantees. You can have parental guarantees. And if you have a bank account within India, you can also ask for post-dated checks. I think Mustafa has also touched on post-dated checks as well. It's I would say it's another good security to have as well. It's a very strong tool. Just a note on securities. If you're talking about bank guarantees and also parental guarantees, there is a procedure to be followed. If for an Indian entity to provide guarantee for a foreign entity or non-domestic entity, so there is some stringent regulatory requirements which needs to be adhered to before you can actually ensure that the contracts are or the guarantees are enforceable. And I would suggest that this is not a straightforward process. So you should always use the expert lawyer's guidance to ensure your securities are enforceable. And you can always also reach out to, we can share our contacts with you, and contacts such as Mustafa is an expert lawyer for India, so he can provide you guidance on how to go about setting up securities and contracts for to be enforced against Indian buyers.
Okay, thanks, Diraj. It sounds like the proper contract between the seller and the buyer is super important. So this is a very important message to our audience. Okay, next question is to Mustafa. You just present several debt recovery mechanisms in your presentation. So what would be the most practical approach for a Taiwanese exporter to collect the overdue receivable in India?
Thank you again, Kevin. The most popular now as we speak is the Insolvency and Bankruptcy Code, because the remedy is really fast. The stat demand notice is just 10 days, and if the debtor fails, you can file the application before the relevant bench of the NCLT, that is a tribunal, and the hearing goes on very fast. So the only condition is that the threshold limit has to be $120,000 plus, and it should be a private limited company who is a debtor or an LLP who is a debtor.
Okay, thanks, Mustafa. Next question goes to Diraj. In Tommy's presentation just now, he mentioned about observed default rate, for which the highest is India and then Asian country. I'm wondering, within the Asian countries, is there any specific one or two country has specifically higher observed default rate, which you may want to remind the audience to be careful?
Sure. I mean, in my experience, what I've observed is if you just put the context of what's happening globally, I think what we see is USA and Germany being the two largest defaulting markets. And if we come more close to home, Asia, then we see Australia, India, Saudi Arabia, China, Singapore, Dubai, and Vietnam also amongst the top 20 defaulting buyers. And I would say, in our experience, if you look at the last 17 months of overdues reported, the names I mentioned within Asia, like Australia, India, Saudi Arabia, China, they've all reported overdues in excess of 100 million euros individually. So yeah, I mean, overdue situation is there, and India is obviously Australia leading the way in terms of the overdue reported. But then I think India is also a growth market, so overdues being reported is I would say it's not a problem. I mean, overdue situation is a normal course of activity in a business. This is just normal. But what we need to have is a proper structure in place to manage it. And what we try to emphasize and also develop is a proper structure to manage these overdues. And if you have that, then Asia is still, for us, is a defaulting market. And if you have a proper recovery structure in place, then you can also recover most of these debts as well.
Okay, thank you, Diraj. Can I ask a very straightforward question?
Sure.
Between India and China, which country has a higher observed default rate?
For the moment is India.
Yeah. Oh, wow. So, okay. So our audience should be very careful about the credit risk in India.
Yes.
Okay.
Have a good contract in place.
Okay. Again, a proper contract is super important.
Clear contract in place. Yes.
Okay. Got it. Next question goes to Mustafa. Regarding to India's election result last month, Prime Minister Modi has to form a coalition government this time. Do you expect Modi is going to launch any aggressive business policy or reform in the near future?
So Prime Minister over the last 2 terms, also this is third term, has always been very progressive in trying to make it ease of doing business in India. And I think he will continue on that path for making it easy for international players to perhaps invest more money in India, and at the same time making doing business easy in India. And a very, very integral part of doing business easily in India is also recovery of money if something goes wrong. And therefore, as you can see, all these laws that I mentioned, they have kind of tightened the laws so that things can go much faster, such as timelines have been like shortened, and more powers given to arbitrator and to the NCLT and other various legislations. So all these are steps towards the same goal of protecting investors' money in India.
Okay. Okay. It sounds quite positive. We're looking forward to it. Okay. As the takeaway at the end of the webinar, I would like to ask Diraj, could you please give us some overall advice about how the audience can better protect their receivable from the beginning of the sales cycle to the end?
It's a very good question, Kevin. I think I would say this is something also close to my heart as well. When you have a say, I'm speaking in context where you have a credit insurance in place, and if you have credit insurance in place, then in my view, I think of any insurance, if you have insurance, if you have purchased insurance, then it's important that at the time of an incident, you get your insurance paid. Similarly, for credit insurance, if you have credit insurance, you have to make sure that you comply with the terms and conditions of the policy. And as an insurer, speaking from the insurer side, I think it's our core responsibility to make sure that we deal with insurance claims professionally, ethically, and efficiently. And the process is quite seamless as possible. And there shouldn't be scope for any surprises for the customers. So to make sure that we avoid common pitfalls, then I think one of the main one is for the policyholders is to ensure that they have a credit limit on the buyer. Occasionally, we find that the policyholders might apply for credit limit on an incorrect buyer. So the policy covers policyholders for contractual amount due from the buyers where the insurer has issued the credit limit. If the policyholder will apply for credit limit on an incorrect buyer, then the insurer will issue end up issuing the credit limit on the buyer which the policyholder has applied on, and then it could be a wrong buyer, so that there will be a problem if you want to submit a claim. And I think as a policyholder and also a supplier, it's important to make sure that you know your buyer, and it's an important obligation also to ensure that when you are applying for the credit limit on the correct buyer, you also know your buyer. So in that sense, that you will be applying for your credit limit on the correct buyer, and you will be also setting up contracts and selling to the correct buyer as well. The second thing I would probably add is that again, it comes down to contract. The common pitfall again is having no official contract, and it's important that we always have proper contracts in place. The insurers do not insure contract risk, and if you want your insurers to actually admit liability, you should have proper contracts. You should be enforcing your contract as well. So I would say you make sure you have proper contracts, seek legal advice. If you need help from us, we can also advise you and direct you to the right lawyers to actually provide you advice as well.
Okay, thank you for your constructive advice. We are very grateful to have both Mustafa and Diraj giving us such insightful session today. Thank you, gentlemen. Bye bye.
Thank you.
Thank you.
Bye.
好，今年的论坛已经进入尾声了，感谢大家的参与。我们汉语保金会继续秉持着帮客户化风险为成功助力的企业使命，持续的引进国际间的各种信用资源来分享给大家。当然，如果你有任何信用风险的问题或印度的法律问题，也欢迎联系我们。我们希望有机会能够为贵公司服务效劳。那再次感谢，那我们就下次论坛再见。
活动已经正式结束，谢谢各位来宾的参与。我们会后会另外发送意见调查，请大家给我们支持及改进的意见。再次代表汉语保金，祝福大家一切顺利，业绩长虹。谢谢大家。